Okay, well, I think we'll make a start. There's still quite a few people due to join, but it'll take a little while for me to get through the housekeeping and things like that. But first of all, welcome everybody, and thank you for bearing with us on the Magical Mystery Tour from hybrid events to virtual proceedings. I'm afraid that was my fault. I've just done a PCR test. I had symptoms yesterday, and we thought it wouldn't be a great idea for people to come in person and then have to be at risk of actually being, infected by me. So we decided to move this over to a virtual proceeding. So thank you all for bearing with me. For those of you who don't know me, my name is Carol Day. I split my time working as a consultant solicitor for Leigh and also for the RSPB, who fund the work that I do on access to environmental justice. I'm also an ELF trustee. And the work that I do for Leigh is really to support the cases that we do over the full range of our work, which is biodiversity convention, conservation, planning cases, major infrastructure and climate change. Little bits of housekeeping. You are all automatically muted and the proceedings are being recorded. So if anybody else wants to come in and listen to them later, they can do that. There is a chat function. Please submit your questions. I know it's always slow in the beginning, but if you can get them in, that's great. And I'll explain the format of the event in just a moment. But I did just want to say a few words about the Aarhus Convention, first of all. For those of you who know me, it's a subject which is very dear to my heart. When I was working at WWF, I remember writing a press release when the Aarhus Convention Compliance Committee had just done their findings about the UK and costs, and taking it to my senior manager, who said it was probably the dullest press release he'd ever had the misfortune to read, because he was so used to seeing press releases about adopting snow leopards and things like that. So I had the challenge of persuading him that participatory rights were just as important in terms of functioning democracy and the importance of the rule of law. But of course, the Aarhus Convention rights, access to information, public participation and access to justice are absolutely pivotal to us as individuals, as community groups, to NGOs and practicing lawyers, all working to protect the environment, whether that's the right to know, the right to engage, or the right to challenge the illegality of potentially unlawful decisions. Now, the Aarhus Convention is 20 years old this year, and it's the 7th meeting of the parties to the Aarhus Convention later this month, which is why we decided to hold this event to mark the start of that meeting of the parties. Some of you might be there actually taking part in that to fly the flag for the UK. And the UK has been a party to the convention for 16 years now. And so it's a good time to think about the UK's compliance with the convention, particularly in this sort of post-Brexit period. Now, the UK has been called the Compliance Committee's best customer because there are 47 parties to the convention. There are 188 communications on the UNEC website. And if you look, about 43 of those concern the UK. That's nearly a quarter out of 47 parties. And that's a high number. Now, you might ask, is that because the UK is a terrible party, or is that because we're really great complainers? And that's the question that I think we're going to look at tonight, with some of our panelists are going to raise some points for discussion. So the format of the event is that we're going to start with an opening speaker. We're then going to have a panel on access to justice with 3 people doing 5-minute contributions each, and then some Q&A. And then we're going to switch to a second panel on public participation, same format, 5 speakers, 3 minutes, and then a short Q&A afterwards before we close at around about 6:30, if you can bear with us for that long, which would be great. Okay, so that's it, I think. That's all the housekeeping. So I think without further ado, I'm going to pass over to our opening speaker, who's Emily Barrett. We're delighted to have Emily with us. She's a senior lecturer and the co-director of the Transnational Law Institute at King's College London, and a fellow at the Centre of Environment, Energy and Natural Resource Governance at the University of Cambridge. She teaches on the undergraduate tort and environmental law modules and runs a special module on courts and social change at HMP Belmarsh. She's the author of a recent monograph, The Foundations of the Aarhus Convention, which provides an account of the spirit of the Aarhus Convention. Her next project seeks to uncover and understand the sacred in environmental law, which I thought sounded really fascinating. So anyway, Emily, we're really pleased to have you with us, and it'd be great to hear from you for about the next 10 minutes. Thank you very much.
Okay, great. Thank you. Can you hear me okay? Good. Well, it's kind of fortunate that this evening is online, because tonight would have been the first time I'd spoken in public since March 2020. And I was a little bit concerned that it would be as if you were all in the back of a car that I hadn't driven for a similar length of time. There would have been lots of crunching of gears, emergency stops, and awkward relationship to the curb. So I think you may have all won in that circumstance, even though you won't be enjoying a nice glass of wine. So this afternoon, I just want to say a few brief remarks about the spirit of the Aarhus Convention, and I will explain a little bit what I mean by that. And there will be many more experts than I who will be speaking really about the function of the convention and whether indeed the UK is a rogue state. But what I hope to do is to remind all of you why this matters and what is the vision that animates what the convention is trying to achieve in practice. So I'm going to be unabashedly academic in what I do, and I hope that you will follow along at least a little bit. But why should you keep listening? Why should you care about this academic flight of fancy into the mythology of the Aarhus Convention? Well, I think there are a number of reasons, but two ones that I want to highlight just now. The first is that the convention is one that requires a purposive interpretation. And the second is that it's a legal instrument with life. It likens itself and has always likened itself to a human rights instrument. And with human rights instruments, we give them, we treat them as living instruments. And I would suggest that the Aarhus Convention also needs to be treated as a living instrument. And in fact, this is what the Aarhus Convention believes of itself. And in the, and I'm just going to read here from the strategic plan from 2015 to 2020, and it says, our immediate mission is to keep the provisions and principles of the convention under constant review and consider forward-looking interpretations of the convention and its further developments, so as to ensure that it continues responding to the modern challenges and provides an adequate instrument to achieve its objectives. But in order to give the Aarhus Convention a purposive interpretation, in order to treat it as a living instrument, we need to understand what the life is that animates the convention. What is its spirit? What are the ideas that drive the vision of the Aarhus Convention? And so I want to just reflect a little on some of those ideas. So in order to try and reflect or to understand what the vision of the convention is and its broader aims, there is an awful lot written that kind of accompanies the convention. There's a massive folklore that gives us a clue or a number of clues as to what the convention is trying to achieve, what its vision and spirit is. And I'm going to read you a few extracts from documents, so you have to forgive me. But here is the original implementation guide of the Aarhus Convention, which rather goofily is signed, I don't know if you can see that, is signed by Stephen Steck, who is one of the authors of the Aarhus Convention. And Stephen very kindly examined my PhD and brought this as a gift. So it's a precious document to me. And in the introduction to the Aarhus Convention Implementation Guide, it has this wonderful paragraph. The Aarhus Convention is a new kind of environmental agreement. It links environmental rights and human rights. It acknowledges that we owe an obligation to future generations. It establishes that sustainable development can be achieved only through the involvement of all stakeholders. It links government accountability and environmental protection. It focuses on interactions between public and public authorities in the democratic context, and it is forging a new process of public participation in the negotiation and implementation of international agreements. The subject of the Aarhus Convention goes to the heart of the relationship between people and governments. The convention is not only an environmental agreement, it is also a convention about government accountability, transparency, and responsiveness. That's an awful lot. The convention wants to say something about human rights. It wants to say something about democracy, about accountability, about citizen action. and not just in relation to the environment. So ambitious is the Aarhus Convention that it thinks it can do something about government accountability just generally. And there's just kind of a shorter quote, which I really, I think reveals just kind of the spirit of the Aarhus Convention, again from the strategic plan from 2015 to 2020, says, this vision and mission are part of our broad aspiration to achieve a more equitable world and a better quality of life. The Aarhus Convention is almost a beauty pageant contest standing on the world stage, telling us that it wants world peace. It is so unabashed in its vision and ambition. And of course, there is a kind of a naivety to this vision. They want to achieve a better world, a better quality of life for everyone. And there's also a bit of arrogance. I mean, that's an awful lot for one single legal instrument to try and do. And I wonder if actually this kind of naive, arrogant combination is the only one that's going to work in the face of all the challenges that we have, particularly in relation to the environment. So what then does taking this vision seriously look like? Well, I think it's trying to dig down into that kind of broad array of aims that are kind of that inhabit the text of the convention, and to try and figure out what they might mean. So one of the key aims that we see time and time again mentioned in relation to the Aarhus Convention, and indeed Kofi Annan speaks about this in his introduction to the first implementation guide, is the idea of environmental democracy. If we take environmental democracy seriously as an idea, what does that mean for how the convention is interpreted? Is it just simply enough to say that if we have consultation with the public, that is environmental democracy? And if we look at what kind of academics are writing about environmental democracy, actually it can mean very many almost crazy things about listening to plants, about having serious conversations and allowing people to deliberate in the processes of government decision making. So if we really think about what kind of this environmental democracy purpose is, it means that how we understand Article 7 and Article 8 about policy formation, about the formation of legal instruments, it means that we have to really consider the role of the public and how we can incorporate the voice of nature. That's one example. And then I would just give you another example. And this one is the one that I have a bit of a love-hate relationship with and has caused me much heartache, I would say. And this relates to environmental rights. And we can look at the convention and say, yes, this is an instrument with environmental rights because we have this set of solid procedural environmental rights that are very clear, well articulated. But if we look at what the first article of the convention says, we have what I think is the trickiest legal provision ever written. So Article 1 is as follows. In order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee to guarantee the 3 procedural rights. But we have this bit of legal drafting that is, you can't quite get your head around what they are trying to say. In order to contribute to the protection of the right. So it's not actually guaranteeing the right, but it's also not a total fluff of a right. If you were just saying kind of the right to a healthy environment was important, you would keep that in the preamble, but it's not in the preamble. It's in the first provision of the convention. It's the first thing that the convention claims to do. So if we are treating the Aarhus Convention as an instrument that should be interpreted purposively, an instrument that has life, we need to try and understand what Article 1 is saying. Is it a mere diplomatic fluff? When the convention was first envisaged, many of the parties, Italy and Norway, wanted to have a human rights-based treaty that guaranteed a substantive environmental right, and many parties didn't. It became too complicated to achieve this right. So did they just put that in there to keep those parties happy? Or are they trying to do something else? Are they saying that, okay, right, now is not the moment to have this substantive right, but we want the convention to be able to respond should the substantive right be kind of part of a broader jurisprudence, if it starts to be recognized in international law, if more nation states implement substantive environmental rights in their jurisdiction. And although when the UK signed up to the Aarhus Convention, it was very clear, this is just a bit of fluff. No one should read anything into this provision other than it's just there to look good. But I'm not sure that that's correct. And in fact, if we look at some of the more recent documents from the Aarhus Convention, particularly in relation to the recent Rome anniversary event, nobody's let go. They have not let go of this bone of the substantive right to a healthy environment. It's still part of the discussion, and it's still something they want to be able to bring forward and ensure that maybe it's something that actually gets clearer legal protection than they were able to give when they first drafted Article 1. So I will close there. I won't give you any more of these wacky examples, but I just want to reiterate that understanding what animates the convention is crucial for highlighting that there's a massive latent potential in the text of the convention. This was not meant to be a static legal instrument. There is so much life, and there is so much more that the convention wants to achieve than might be seen at first appearance.
Thank you very much, Emily. That is really interesting. I love the vision of the document as, you know, an ambitious and living document that is going to, you know, set to and always intended to evolve with the times. That's great. I wish I had a signed document by Stephen Seck as well, but I can't unfortunately say I have that. But that was really great for giving us the platform to go forward. So thank you for that. And we're going to start with our first panel now, which is on access to justice. We've got three speakers. We've got Ricky Gamma, Ricky's a solicitor in the Human Rights and Public Law Departments at Leigh, focusing on environmental claims. He has extensive experience in environmental and planning law, including in JR proceedings in the High Court at all levels. This involves frequent advice on the Ahus cost capping regime in the English courts. He's also co-authored a chapter on Ahus costs in England, shortly to appear in the Aarhus Convention Coming of Age, published by Hart. And before joining Leigh in 2021, Ricardo worked at Richard Buxton Environmental and Public Law after several years as a planning lawyer and founding associate of Town Legal, a leading planning firm. Okay, we're then going to move on to have Katie DeCow, who's just joined us, slipping in. Great, Katie. Katie is a lawyer at Friends of the Earth, specialising in environmental JR, and has a lot also of practical experience of the Aarhus cost capping regime. She's worked on Friends of the Earth's judicial review challenge to Heathrow expansion and is now acting on an NGO intervention in the Sarah Finch Horse Hill oil and gas case, which goes to the Court of Appeal later this year. And that's a Leigh case, so we're delighted that Friends of the Earth are intervening in that. She's also currently working, and probably why she's just slipped in now, on the Whitehaven coal mine, the public inquiry which is taking place at the moment. She's also working on two communications before the UN Compliance Committee, one on costs and also one on Wednesbury unreasonableness, which I won't say too much about because she's going to be talking about that today. And also another communication, also I should say, on Article 8 and the failure of the UK to transpose that requirement into UK law. And then finally, we have Sarah Sackman. Sarah's a barrister at Matrix Chambers with a wide-ranging and successful public law practice, including planning, environmental education, local government, welfare, election, discrimination law. She's recently joined Matrix Chambers from Francis Taylor Buildings. Her experience covers the appellate courts at all levels, and she regularly appears in planning and enforcement inquiries. She specialises in High Court work, acting for claimants and public bodies alike. Notable clients include the Equalities and Human Rights Commission, the Mayor of London, Friends of the Earth, and Shelter. So those are our three speakers, and I'm going to ask each of you, when you've done your 5 minutes, can you then pass on straight to the next person? We'll go straight through, and then we'll have some Q&A after that. Okay, thanks very much. Can I first of all hand over to Ricky to start us off? Thank you.
Great. Thanks, Carol. So we're going to move now from the lofty ambitions of the convention, which Emily was talking about, to the more sort of nitty gritty of the UK's implementation of one aspect of the convention. So I'm going to speak about the area where there has been the most consistent and blatant lack of compliance by the UK with its obligations under the convention. Broadly, Article 9.4 of the convention requires that access to justice in environmental matters is fair, equitable, timely, and not prohibitively expensive. In the UK context, that means that claims for judicial and statutory review, which raise environmental issues covered by the convention, but also certain private nuisance claims, must meet those 4 criteria. Essentially, people and organizations who think that environmental damage is being or will be caused by some illegal action should be able to check whether that's the case without being put off by the cost of doing so. And without meaning to offend present companies, because I think there are a lot of lawyers in this virtual room, lawyers in the UK aren't generally very cheap. And I don't have any doubt that most people, when faced with a fee estimate for a JR, would be put off. The government has taken slow steps towards complying with Article 9. After a lot of prodding from previous meetings of the parties, and probably some of the people in this room, the government introduced a mutual cost capping regime in environmental judicial review cases, recently extended to statutory review as well. I won't go through all of the iterations of that regime since it was introduced in 2013, but as most of you will know, it is now in most cases possible to get a cost capping order limiting a claimant's potential cost exposure to £5,000 for an individual and £10,000 for anyone else. There are, though, quite a few caveats to that general rule, the biggest of which is the requirement introduced in 2017 that in order to benefit from the default caps of 5k or 10k, a claimant has to share with the court and with the other parties details of their financial resources. So on the one hand, the cost caps definitely have made things much easier for claimants in environmental JR cases. On the other, that improvement was starting from a pretty abysmal baseline in terms of the number of environmental cases that could be brought, which has only been exacerbated by the legal aid cuts since 2010. In the lead up to the meeting of the parties in a couple of weeks, the Aarhus Convention Compliance Committee has published a report on the compliance of the UK with the convention, which identifies a number of remaining areas of non-compliance, which I'll summarise very briefly. First, the fact that the regime is overly restrictive in the type of claim it covers, in that only judicial and statutory review claims are caught, and not private nuisance claims, which raise environmental issues. Second, the fact that there is ambiguity about how the default caps apply to unincorporated associations, where on one understanding of the rules, and depending on the constitution of a claimant, which is an unincorporated campaigning group, the 5k cap is applied to all members of the group individually. Third, the fact that successful applications to increase the default cost caps are far more common than successful applications to decrease the caps, meaning that the ability to vary the caps appears mostly to operate as a one-way ratchet. Fourth, the requirement to provide a schedule of financial resources is, according to the ACCT at least, an unnecessary burden and potentially unfair. And then fifth, in cases where there are multiple claimants, the aggregation of caps per claimant is, according to the ACCT, unjustified. And there were other concerns raised about cost protection on appeal, cross undertakings for damages, and cost protection for interveners. So we've got pretty clear areas of non-compliance by the UK, and it seems likely to me that the meeting of the parties will adopt the findings of the ACCC. They've also recommended that the UK is directed to publish a plan of action by July 2022, with the timetable saying when they'll rectify the issues that have been identified. A previously announced review by the UK into the cost protection regime was shelved last year, allegedly due to COVID. But that was an excuse which the ACCC didn't buy, given that the government did find time to go through with the independent review of administrative law. In the meantime, the current government doesn't seem to have any appetite for brownie points for compliance with international law, and definitely not for giving judges more power to review the actions of the executive. So I don't really see where we go from here. I can't say much more than that, but for now, I'll pass over to Katie to speak about a potentially more interesting subject, which is about what happens when public law claims do go to court. Are judges going too easy on the government? Is the standard of review not intense enough?
Thank you, Vicky. I shall certainly attempt to make it as interesting as possible, although yours was also very interesting as well. I think you're selling yourself a bit short there. Thank you, first of all, to Leigh for inviting Friends of the Earth to speak at this very interesting seminar. The focus of my talk is going to be on the joint communication that Friends of the Earth Scotland, RSPB, and of course Leigh have brought before the Aarhus Compliance Committee. And our concern is in relation to the standard of review that is applied routinely in our courts in the context of environmental judicial reviews. So the issue really is that the Aarhus Convention requires there to be a means to challenge the procedural and the substantive legality of decisions, and for that to be done in a way in which adequate and effective remedies are guaranteed. And moreover, there needs to be a transparent and consistent legal framework so that it's not some kind of fortunate chance that is possible. And the issue in our courts is that is simply not happening. The Wednesbury standard, which is technically a sliding scale, but the standard that is applied routinely by the courts is a very strict Wednesbury standard, which means that the courts will only intervene if the decision is perverse. So they're not going to, they have a really hands-off approach to this, and a huge amount of discretion is afforded to the decision maker. And we believe that is simply not sufficient in order to comply with the Aarhus Convention. So that is the basis of our communication. We filed this back in 2017, and we had a substantive hearing before the Aarhus Compliance Committee back in November 2019, and we are currently awaiting the draft findings from the committee. I want to emphasize that our communication is not a demand that there needs to be a full-blown merits review in order to ensure compliance with the convention. This is about instead ensuring that there is a more careful scrutiny applied to environmental judicial reviews. And that's that is specifically because of the rights which the Aarhus Convention guarantees, and because this government has repeatedly stated that they are committed to the Aarhus Convention. So I think one of the key things from the communication and from the proceedings that has come out is that the government doesn't defend conventional or strict Wednesbury as being compatible with the convention. What they have said, and what we argue against, is that there are some examples of cases which show that intent standard can be applied and is applied by courts in this country when it comes to environmental judicial review. We don't think that that is accurate at all. And if you look at the cases like McMahon, for example, which concerned a license for the culling of buzzards, that seemed to potentially open up the possibility of a more careful scrutiny being applied in environmental cases, but then subsequent case law such as Dillner, which concerned tree felling, have really shut that down. And indeed, there is an issue as well with a disconnect between what the UK government is telling the Aarhus Compliance Committee in our proceedings with this communication, and then what they are going on to say in court proceedings. So when, for example, in the case of Swire, which is a 2020 case, the claimant pointed out to the Secretary of State that that the government was arguing that a more anxious standard of review was suitable and possible for the court following the McMahon decision. That's not what the Secretary of State went on to plead. They went on to plead that it was only conventional Wednesbury that was appropriate in this environmental JR. So I think that's something that is very concerning, that we have these two different angles being promoted at different times and depending on the arena that the government is finding itself in. So I would just emphasize that this communication also has there's real practical concerns behind bringing this case. So as it stands, it is very, very difficult to challenge the substantive legality of environmental decisions. That is a particular concern in the context of the climate emergency, where we know full well that our government is not doing enough to make the decisions that it needs to ensure that we are addressing this crisis and addressing it now. And as a result of all of this, it means that environmental cases are simply not being brought because claimants are having to be advised that the prospects of success are so low because of this strict Wednesbury interpretation. And also, even if they do bring proceedings, then they are losing in court because, again, the courts are insisting on sticking to this strict interpretation. So a lot of real world practical consequences to this, and that's why we believe this is such an important communication and why we're hopeful that the Aarhus Compliance Committee is going to release draft findings vindicating our position on this. Thank you. And now I think I need to hand over to Sarah.
Thanks, Katie. Thanks, everyone. I was reflecting when Leigh kindly extended the invitation to speak today on when I first started out, which is now a sign of my age, practicing in environmental law, and that was, if I say it was well over a decade ago, that gives you some idea. And we were really in the foothills, I think, of understanding how the Aarhus Convention would affect environmental litigation in the domestic context. And although I think what I'm about to say, echoing and taking up the baton from Ricky really about the extent to which the promise that Emily spoke about hasn't quite been fulfilled in terms of the reality of environmental litigation. I think it's also important to reflect on how far we've come and the notion that access to environmental justice shouldn't be prohibitively expensive. That concept is a profound one. And, you know, when I started out in practice, it was just a couple of years after the corner house litigation, which established protective cost orders. And now we do have our own distinctive cost capping regime, which I think recognises both the importance of public interest litigation in public law generally, but also because we've got this specific cost capping regime in environmental claims, I think it does underscore the prominence that environmental law has in the English courts, and which it will continue to have as environmental cases and concerns dominate. But I think it's also true to say that we really stand at a crossroads at the moment, whereas we said, as Ricky said, you know, waiting to see what the ACC has to say, and I think it's very difficult to make predictions about the direction that the UK will take in terms of its international treaty obligations generally, but it's specifically in relation to the Aarhus Convention. And that's because the direct effect of Article 9.4, which Ricky was telling us about, through EU law has gone, and with it the ability and the ultimate threat of taking litigation to the ECJ. But obviously at the same time, with COP on the horizon and huge public pressure and interest in tackling environmental challenges, there will also be enormous pressure to get this right. So it'll be interesting to see as we stand at this crossroads. But That's all very interesting and highfalutin, but what does it mean when we're advising clients day to day, as I know Ricky and Simon and others and Carol are being, rung up every day with new environmental or potential environmental instructions and challenges that want to be brought. What is it at the coalface that is of concern to our clients? Because I think it's fair to say that the cost capping regime, although it's come a long way, continues to fall short of compliance and has very real world implications in terms of the kinds of cases that get brought and the fallout from those cases. And there's a lot that one could say, but I just want to identify or highlight 5 issues that crop up time and time again in the cases that I do, and that show that this stuff really matters on the ground. The first is the lack of transparency. So when we're talking about cost capping decisions, as I think others have noted, it's really hard to get hold of these decisions. Why? Because the point at which they're determined, although it's a good thing, happens earlier in litigation at the permission stage. Very, very difficult to get hold of those decisions, to understand how they're being determined and to sort of identify patterns in those. So there is a lack of data. I remember when my former colleague Ned Westaway, who was involved in the CPRE Kent case in Supreme Court, he did a shout out round chambers and said, look, who's been involved in cases which have reached the permission stage where cost caps have been varied or one way or another. It's really hard to monitor what's going on because we just don't have the data, don't have the decisions. So number one is a lack of transparency. And that links to a second problem, which is a lack of predictability. When clients come to us wanting to bring a judicial review or a statutory review, the first question you get, practically the only question you get, beyond have I got a runner, is how much is this going to cost me? And hand on heart, it's very, very difficult to say. It's very, very difficult to advise clients on how much their environmental litigation is going to cost at the starting point, because I suppose because of 2 things. One, although the Aarhus cost capping regime, as it's now codified in the CPR, is designed to offer certainty, and we have these default cost caps, and yes, that does represent progress. Where those can be varied and ratcheted up, to use Ricky's term, it's very, very hard to say for certain what the thing is going to cost you. And of course, it's not just defendants that can apply to vary a claimant's default cost cap. Interested parties too, following a recent case, Bertoncini and the London Borough of Hammersmith and Fulham, which said that interested parties can also apply to vary cost caps. So it's very, very, very difficult to be able to advise a client, well, what level of financial resources do you have to reach before you are in danger of being met with an application for variation of the cost cap. And that's been highlighted in 1 or 2 decisions that we have seen in the courts, CPRE in Surrey and Waverley Borough Council as an example of that, where a cost cap, the default cost cap in relation to that group, CPRE Surrey, which would have been £10,000, was elevated, doubled to £20,000, in part on the basis that they had shown themselves to be rather good at fundraising for administrative law challenges. So you're sort of a victim of your own success. But in terms of the fundamental question that clients are worried about, how much is this going to cost me? It's very, very difficult to advise. And in the absence of some kind of guidelines or protocol as to when you're going to start hitting that threshold, at which point a judge will start to look seriously at an application to vary, it's very, very difficult. And so it's unpredictable. And that has a chilling effect on litigation. Third point is this, I'm going to borrow Ricky's phrase because I like it, the one-way ratcheting, the ways in which defendants are getting more and more canny about exploiting the cost regime to gain litigation advantage. applying for variation really as a tactic to try and snarl up the opposition and ward them off. And we've seen this in other contexts, not purely in the environmental context, of where cases that fall outside the Aarhus protection regime, we're seeing defendants applying for security for costs. The We Love Hackney litigation, where the local authority there successfully applied for that, and it effectively sunk the litigation. So I think we should expect to see, and again, hand on heart, when I've acted for public bodies, one is looking for opportunities to question whether the Aarhus cost cap applies at all, and if so, to what extent, just to keep the pressure up on claimants and make their lives difficult. And that's a reality of this kind of litigation. Fourth point is the operation of reciprocal caps. I won't say too much about this, but we're talking at a Leigh Day conference, and I know that these reciprocal caps and the way they work can make the recovery of one's actual costs, even when one has been successful in prosecuting an environmental claim, difficult. Of course, one can take the gamble of opting out of the default cost caps, but then of course you leave yourself exposed if you're unsuccessful. But I've heard many an environmental claimant lawyer complain about the reciprocal caps, and I don't know of any examples of where the default caps and defendants have been varied upwards, but I can see people shaking their heads. I haven't come across it. The CPR regime does allow for it, but I haven't actually come across it. And the fifth point is this point about having to provide a schedule of financial resources. I said before, the number one question that claimants have is, how much is this going to cost me? You say, well, roughly £5,000. They should be capped at that, plus our fees, it should be fine. But then you say, right, we've got to produce a schedule of financial resources. And that can be, for many clients, something that really puts people off. It's experienced as something that's really intrusive, to have to disclose significant assets, income, and also other sources of financial support, whatever that means. And because there's no standard form, again, a complete lack of predictability, I think to err on the safe side, and in the interest of transparency, it may be that we're advising our clients to disclose more than they actually need to in order to discharge that obligation of producing the schedule in the claim form. All of this is very sort of, granular and detailed, but it is the point of it, when we're talking in the context of cost capping and access to justice, is if these are things that are erecting barriers between potential litigants and their public interest claims and access to the courts, then they have real world effects and ripple effects, and we're all the poorer for that, because it means that good claims are not being brought forward, and it does mean that it's not a case that justice is truly open and accessible to all, but only to those groups or individuals that can afford it, and that's a real shame. So I'm sorry to end on a bum note, having started on a hopeful note, but thank you again very much for inviting me to speak.
No, that's brilliant. Thank you all three. That's fantastic. We've got about 10 minutes for some questions. I just wanted to say, first of all, that the thing that really leapt out to me there was the lack of transparency. Many times we have asked the MOJ for data on environmental cases. Every time I do it, I get a shocked look and a 40-day EIR request, because they go off to the courts and they have, as if they've never been asked for it before. And this is a point that's been made by the Compliance Committee in being, they can't actually assess the effectiveness of some of the UK measures because they don't have the data. So having data about the number of cases, how successful they are, what are the costs of orders that are granted, what are the injunctions, this is just fundamental data which we just don't have. So I totally think that's a really key point. But we've got a question that's come in. We've also got a couple of questions that have come to us directly. We've got one question, first of all, though, which I think is probably for Katie. And it says, do you think a HRA-esque statute permitting proportionality analysis would resolve the issues regarding standard of review? So I wonder if Katie would like to start on that, and then perhaps if I can go over to Ricky to pick up on any questions. I think he's had a couple of questions in. Thank you.
Thank you for the question. I think that would go a long way towards resolving it. I don't think it is absolutely necessary to resolve it. I think, as I said, there have been cases where a more careful scrutiny has been applied. And just to sort of illustrate what I mean by that, it's things like, you know, the courts being willing to grapple with the issues more, being willing to ask, has the government actually made sufficient inquiries? Are there lacuna in this? Rather than just assuming that the decision maker is right once they get into any sort of technical area. So I think proportionality is certainly one answer to that. I think there are others as well.
Right, and yeah, I'll just cover some of the questions that we've had in directly, and I'll give this to you, Sarah, if that's okay. So crowdfunding has crowdfunding's obviously changed things quite a lot, and it's done a lot to help make it easier to bring environmental JRs. But does that mean that only claims which raise issues which interest the public are not prohibitively expensive for the purposes of the convention?
Yeah, I mean, I think that's really interesting, isn't it? Crowdfunding, because it has changed the complexion of this area of work. I mean, in some ways, in the absence, well, both in the context of very expensive litigation and in the absence of other forms of legal support, I suppose we should be grateful for it. But it does, I think, lead to a distortive effect whereby, you know, popular or populist cases get well funded, and other very worthwhile and equally important cases, for whatever reason, which don't grip the public imagination, don't achieve their fundraising target. And I think the other point, you know, I mentioned the CPRE Surrey case. It's a bit like in the legal aid context, where increasingly the legal aid agency seeks a community contribution. And, you know, I can see some force in that, but for some communities, it's easier to raise money than others. And I don't think, you know, the prohibitively expensive test is supposed to be, following Edwards, a sort of combination of both a subjective and objective test. And simply because your case, if you're lucky enough, captures the public imagination, you're able to raise lots of money. Does that mean that you should still not be able to benefit from a meaningful cap? I don't think so. I just want to say one other thing, just picking up on Carol's point before about the lack of data. I was reading a really interesting article about use of algorithms and AI in judging by Tim Harford, the undercover economist guy. And he was talking about, you know, the extent, I mean, I know we find this quite scary, the extent to which algorithms can help us make more consistent decisions. But, you know, the lack of transparency is not just bad for environmental campaigners and litigants. It's bad for judges as well. It would actually be quite helpful to know if what you're doing is in keeping or consistent with what other judicial colleagues are doing. And having that data actually benefits everybody. It benefits, I think, you know, the administration of justice. So I just wanted to say I very much agree with Carol.
Can I just say something on that as well? I think it's not really just the data either, is it? I mean, I think if you had the judgments and the reasoning, you might end up having a consistent set of principles, which would then give you the predictability. So one of the frustrations is it's very unusual to get a reasoned judgment on the cap lifting or the cap extending, and so you're always very much in the dark unless you've done a case before or had the same judge before. You're very much in the dark about how the principles are going to be applied. So I think it's judgments and data that we need, isn't it, really?
And that's probably for the judges as well. I mean, I think the judges are just as much in the dark about whether or not the cap should be varied as anyone else, which is a bit worrying given we have a common law system.
Thank you. I think I've just got time perhaps for one or two more. I'm going to abuse my position slightly because something that really occurred to me also, thinking about what Katie was saying, and this goes to me sort of mentioning judges as well, was this sort of somewhat paradoxical position we have where the High Court at the moment sort of sees things as macro-political and therefore says, because they're macro-political, we're not going to actually scrutinise them. And so it seems ridiculous that you have sort of incredibly important issues affecting, you know, huge numbers of people of high public interest, and yet they're getting the lightest touch of scrutiny. I don't know whether anybody had any view on whether they've had that line used to them. We've had it used on us, on our cases, quite a lot, but if anybody's got any thoughts on that. Nobody brave enough to.
I mean, I'll start off if you know if no one else. I'm sure Sarah and Katie have their own thoughts. But yeah, I mean, we've seen that a lot of, and obviously in the sort of in the big, you know, judgments that you know are about these in the environmental context about these, you know, huge infrastructure projects like Heathrow. And it seems, as much as anything else, the judges seem terrified that they're going to be stripped of any ability to review the actions of the executive, unless they say, oh no, honestly, what we're doing here is only looking at these very you know, procedural points, and we're not having any political role at all. But you know, apart from anything else, if something's unlawful, then it's unlawful. And you know, the laws that are in place have been through the political process. So you know, for the judiciary to wash their hands of it because they're perceived as political, even if they engage matters which, you know, have been brought into effect in English law, and you know they've gone through Parliament, then you know, well, obviously it doesn't seem appropriate in my view, but that's what a lawyer would say, I guess.
Okay, do we have any more questions, Ricky? I think you had one or two more, but then I think we'll then move on to the second panel. Perhaps just one more question.
Could I just add to that quickly, Carol? Yeah, I just wanted to agree with everything that Ricky said, and certainly in Heathrow, that was something that was emphasised very much, particularly in the divisional court, about the breadth of the discretion. I think also that all of this is operating in a broader political context, and you know, we've had Mail on Sunday, or what was it, Daily Mail headlines about, you know, traitors to the people, and then we've had the independent review of administrative law, and a lot of talk by certain politicians and newspapers about judges becoming political and stepping on the toes of the executive and on the toes of the state. So I think all of this is a very unhelpful context to our court system being willing to, you know, really seize metal on this and make rulings which are actually and approach cases, environmental cases, which are in keeping with our obligations under the convention. And that's why I think that it's only going to happen with a finding by the ACCC, and then the government taking steps to introduce it afterwards.
Yeah, I really again endorse what Katie just said, and I think that that wider public law context about justiciability and debates around the scope of judicial review is really important. And I think, regrettably, and this is my personal view, that has post the Miller Brexit litigation has now filtered through to our courts. And I think if you look at some of the recent judgments of the Supreme Court, and particularly, and I'm because I'm sharing a panel with you, Katie, you know, some of the dicta about NGOs bringing political litigation. I'm thinking of the CPAG case, some of the criticism that was levelled, I think, at the Howard League, but, you know, different contexts, not environmental cases, but, you know, very much the Supreme Court sending a signal that it's inappropriate to bring these kind of politicized challenges. And yet, of course, all these things have a political context. And very often it's NGOs like yours that are best placed, because you've got that kind of strategic expertise to identify the cases that really are going to, I suppose, be worth taking. And you know, if a case has reached the Supreme Court, presumably it's because it's finely balanced. So I think that is part of the wider context that is both a political context, but now I think seems to be informing the very top of the judiciary.
Okay, look, thank you for that. We could go on for that. I could talk about that for hours, but we've got a really interesting second panel that I want to get to. So I'm going to introduce our next three speakers now. Apologies first of all that Steve couldn't make it with us this evening. He's had to withdraw, but we are delighted that Simon Ricketts has stood in to help us out. Simon specialises in planning, compulsory purchase and related public law issues in relation to a major mixed-use development schemes across England. Before co-founding Town Legal, he was head of planning and environmental, the first at SJ Berwin and then at King & Wood Mallesons. He's been ranked as the country's most highly rated planning solicitor for the last 11 years running in Planning Magazine's annual survey, and he's author of a Simonicity planning law blog. Our second speaker is Jenny Wigley QC at Landmark Chambers. Jenny practices in planning, environment and local government law. She appears regularly in planning inquiries and in the High Court, Court of Appeal and Supreme Court in JR statutory review claims, including those related to adequate consultation, legitimate expectation, heritage, habitats regulations, EIA, SEA, air quality, Section 106 obligations and conditions, all of the language we're very familiar with, GDPR enforcement, interpretation of policy and adequacy of reasons, and she's taken silk this year. And our final speaker, by no means least, is Naomi Lou Thompson from Rights Community Action. Naomi is an experienced environmental campaigner and expert community trainer, coordinator and project lead. She's also a senior lecturer on sustainable futures at Oxbrookes University, and she was formerly a senior planner at Friends of the Earth, England, Wales and Northern Ireland. So perhaps we could use the same format as before. If Simon could start, then pass over to Jenny, and then we'll pass over to Naomi, and then we can finish with some more questions at the end. Thanks very much.
Well, thank you so much, Carol. Thank you, Ricky and Leigh, for inviting me to speak and to fill the large shoes of Steve. And I suppose I became really interested in the protections provided by the Aarhus Convention when acting for many of the objectors in relation to the HS2 project and pursuing that ultimately unsuccessfully all the way through the courts. And I loved Emily's introduction and talking about aspirations of world peace and talks of beauty parades. And it got me a bit depressed when I thought about where our planning system is, because when we focus on public participation, what I want to do is really give a very general overview as to where we are with planning reform at the moment and what it might mean for public participation, and to look at, because it's important to have that in context with other reform, particularly in relation to environmental law post-Brexit, and also proposed reforms to the judicial review process. But I'm very much going to be focusing on the planning side of all of this. And, you know, we go back to the beginning of August last year when the government published its Planning for the Future white paper with a foreword by the Prime Minister, which talked about the aspiration of tearing up the existing planning system in order to have a system that worked better to achieve the government's objectives. And there are two real parts to that which raise issues in relation to public participation. The first is the proposal for a more zonal approach to planning, where local plans would allocate growth areas, renewal areas, and areas for preservation, for protection. And growth areas would bring with them automatic planning permissions. So the government made much of the fact that there would be enhanced public participation at the stage where plans were formulated and consulted upon. But you know, once a plan was adopted with a growth area, there wouldn't be a subsequent stage at which the public would have the ability to make representations in the way that they currently do when the application for planning permission comes forward. The other main area really was the fact that the government envisaged handing down minimum housing targets to individual local authorities, and in some cases combinations of authorities, for those authorities to divvy up the numbers, but with no formal process for those authorities or anyone else, whether community groups or developers, to question the numbers that have been handed down. So again, questions arising as to principles of ensuring that there is adequate public participation. So that seems a long time ago. 44,000 responses to the white paper. The government still hasn't published its summary of those responses or its intentions as to the way forward. But of course, big politics, even before Michael Gove was appointed as the new Secretary of State of the renamed Levelling Up Housing and Communities Department. In the summer, we began to have noises reported to us in the media that the government was intending to take off the rough edges that people don't like in the proposals. And since Michael Gove has taken position, what we now know is that there will be a pause in the proposals, and because we read all of this through the mediation of whatever spokespeople tell the press, it seems that we're going to see a much less ambitious set of changes. We're probably not going to see that zonal approach with those growth areas because people in relevant constituencies don't like that. We're probably not going to see numbers for housing automatically handed down to areas because people in relevant constituencies don't like that either. We're going to see probably more of a fixer-up bill rather than a demolish and rebuild bill as far as the planning system is concerned. But the bill and the white paper is only part of the picture at the moment, because of course the government is still embarking on its aspirations of removing many types of development from the traditional planning application process. And Naomi will no doubt be talking about this in terms of the general permitted development order changes, which have removed the need for a traditional planning application for many forms of development, and the changes to the use classes order, bringing many types of commercial use into one use class E, and with all of this, a much reduced public participation in proposals, because usually there'll just be an application for prior approval under the general permitted development order with only limited issues up for consideration. So one theme apart from the white paper is the drive towards away from traditional planning applications. Another theme is the drive to digital, and a complex set of issues, but that was one theme of the white paper, which has really subsequently been turbocharged by COVID in terms of the very swift move to virtual planning committee meetings, which was enabled by emergency government, by legislation, but with a sunset clause, which is now come upon us, so we can no longer have virtual committee meetings. It might be interesting to discuss in due course whether that is good or bad for public participation. Similarly, we had very quickly virtual hearings and planning inquiries arranged by the Planning Inspectorate, and now very much a government drive away from that back to physical hearings and inquiries, and query, are we missing a trick in terms of ensuring that there are better ways for the public to engage in these processes. Another strand I wanted to mention is back to what Emily was saying about beauty parades, because much of the planning system, I think, is going to be reduced to a beauty parade, because we've seen the focus now on design through the building Better Building Beautiful Commission, Sir Roger Scruton and all that lot, which is resulting in a national model design code, which is basically a set of guidelines which should be followed by local authorities and local communities to consult as to local design codes, and then development should be judged against those local design codes. And the guidance within the National Model Design Code is that consultation and engagement should arrive at what the majority of the people want in their area, which all sounds lovely, but it really depends who you ask, whether you're asking the people who need housing or whether you're asking the people in the area who have got very strong views about what should happen in their locality. So I think, again, we're going to see some interesting questions about public participation. And from comments in the press in the last few days, it seems that that concept may be, taken even wider in terms of making planning much more of a sort of voting process on individual issues. So increasingly populist, does that mean better public participation? Question mark. And the only final things I'd say are, I mentioned changes to environmental law. To my mind, that's entirely intertwined with the planning process. So reform of environmental impact assessment, strategic environmental assessment means we need to be very alert to what that means for the information that will be available at particular stages in the planning process for scrutiny of what the likely impacts of particular proposals, whether projects or plans will be. And I think I'll probably leave it there, Carol, and pass the baton on to Jenny. Thank you.
Hello, everyone. Thanks, Simon. Thanks very much. That does lead very neatly into what I was going to talk about, actually, which is sort of how in practice the rights to public participation and the aspirations of public participation in the Aarhus Convention, how those are enabled in practice and enforced by the courts, because obviously the Aarhus Convention does not have direct effect, and very much we rely on the European, what were the European directives and the European environmental impact assessment regulations and the SEA regulations to enforce those kind of rights and be able to take direct action in the UK courts about that sort of public participation. And I thought I'd just give a little bit of an overview of my experience of cases doing that. Not one of my cases, but I think the high watermark was probably in 2000. Obviously, that was before I think we were part of the Aarhus Convention, but certainly with the beginning of the EIA regime being implemented, and the Berkeley case, the Dido Berkeley, who was campaigning against the redevelopment of Fulham Football Club, and took to court the proposition that the planning decision was ultra vires because there'd been no EIA screening decision and no environmental impact assessment. And the court, the House of Lords, took a very robust approach. Lord Hoffman quashed the decision and also held that the courts didn't really have much discretion not to quash when there was a breach of that type of European directive requirement, and would say that there was only really a very narrow basis on which the court could decide not to quash, and that was if there was substantive compliance with the procedural requirement, even if it wasn't actually to the letter. And so they didn't need to show substantial prejudice, basically, if just because the court, Lord Hoffman made very clear that it wasn't enough to just have a series of documents that were available that had some of the information in. So, for example, a statement of case in the appeal and some other information, some witness statements or some proofs of evidence. That wasn't enough. And he used the very apt term that it wasn't suitable to have a paper chase for members of the public to find the information. And that was a really helpful standard, I think, that was set then. But obviously over the preceding 2 decades, that's been progressively weakened by the courts and the Supreme Court decision, particularly leading to the Walton and Scottish ministers case, where the scope of discretion not to quash has been significantly broadened and made the same as in just general domestic judicial review cases, where if there's if the decision would inevitably have been the same, had the right not been followed, or if there's no substantial prejudice to the claimant, then there's a perfect justification for the court not to quash. And of course, that reduces the impetus of all the public bodies to get it right in the first place. So I've had a couple of examples of that. I'll just give you a story of 3 public local plan challenges that I've taken. So one a few years ago, Kendal and Rochford, a woman very keen on the local planning of her area, very enthusiastic in finding out all the information, participating in the local plan examination, following the putting in representations, appearing at the examination. And she was very frustrated that the consultation responses weren't properly taken into account. And we took a challenge to the local plan on various bases, but one of them was that the environmental report and the strategic environmental assessment had not been properly consulted upon. And we actually won on that because Lord Justice, or actually Mr. Justice Limblom, as he then was, said that just advertising it on the council's website was not sufficient if you didn't actually alert people to the fact it was there. You couldn't just put it on your website, you had to actually notify the interested public. And we won on that as a matter of principle, but we then didn't get any relief because Mrs. Kendal had been so good and tireless at finding out all the information and making her representations that ultimately she suffered no prejudice and the decision would have been the same. That was the first thing. Another one, we had a case I did with Ricky more recently, the Airborough Neighbourhood Development Forum challenge to the Leeds site allocations plan. We brought that on a number of grounds, and happily we won on a number of grounds, so it was good. But there was one ground we didn't win on, which again was strategic environmental assessment consultation, and it was about the assessment of reasonable alternatives. And it was reasonable alternatives through the change. There'd been a change during the process, so then a number of alternatives as to what the council would do about the change in housing numbers. And the court made the statement that the documentation was extraordinarily and exceedingly confusing. There were a number of documents that were called Appendix 3 to the Strategic Environmental Assessment, for example. They were all different documents, but they were all called Appendix 3. The actual document, which was about the consultation on reasonable alternatives, was hidden behind a different document, and no one had found it at all. We didn't see it until the witness statement came out during the litigation. And so, again, there'd been no proper consultation on that. There was clearly a technical breach of the procedural requirement. But the court said, Mr. Justice Liebman said, confusion over documents does not itself amount to an error of law. Now, if of course we'd had the paper chase, if that paper chase kind of principle had applied, I think that would have been quite strong. I mean, as it happened, we didn't need to push that ground too strongly because it wasn't our strongest ground, and we went on other grounds. But again, there was no prejudice because our very enthusiastic client and very diligent client had made the points, even anticipating what the alternatives might have been, even though she hadn't actually seen the consultation on the alternatives. And so you have this sort of slightly paradoxical situation where you're punished if you are an enthusiastic and diligent member of the public, and that the system only works because you're not prejudiced, you've managed to do it anyway. But if you're an enthusiast or a zealot with kind of vast reserves of time, energy, and perseverance, then you manage to participate. But my understanding of the Aarhus Convention is that it's there to one of its objectives is to ensure that people, individuals, stand up for the environment because the environment can't stand up for itself. And if you're only relying on those who have, you know, excessive reserves of energy to actually pursue it to the nth degree and then bring litigation about it, and then those people can't get any relief, who knows what other people in the hinterland, the members of the public who weren't as diligent and superhuman as those people, who knows what input they may have had if the documents had been more accessible, and if the, you know, if the system had been more kind of clear and transparent. So I think that that sort of narrowing or widening of judicial discretion not to quash has been a real step back in following the principles of the Aarhus Convention. I mean, just, I think I've learned through that. Another local plan challenge I did was against the inadequacy of consultation on the main modifications of the local plan. So the main modifications were that the inspector basically was deciding that the local green space, which was being put forward in the local plan, should not be designated as local green space. But his change in the main modifications was so opaque, it literally was a change of word from as or to. It was so opaque that nobody at all understood what the main modification meant. And so the strategic environmental assessment on that change didn't actually understand the change, and none of my clients understood the change. So we very clearly demonstrate that there was not adequate consultation on the main modification. Then, of course, we came to, well, would it have made any difference if it had been there? What would you have been able to do? And the advantage we had in that case was that my client was actually in favour of the plan. So because the local green space was being promoted as part of the plan, their rights to object in the examination were limited because they were supporting the plan, they weren't objecting to it. And so when we came to the High Court litigation, we could use that to our advantage to say, well, actually, if we'd known that we were actually an objector to what was ultimately being promoted by the main modification, which reversed the position, we would have been able to have put in much more information. And there's all these things we could have said, and there's all these documents we could have put forward. And so we could really demonstrate that it would have made a difference if we'd been properly consulted throughout the procedure. And for that reason, we got relief. But it does seem a bit of a topsy-turvy way round, really, that the court focuses on that particular claimant, who often is the one who has covered all the bases anyway, and means that all the other people are left behind and are not enabled proper public participation. So that's the sort of downside point. An upside point, perhaps, is I think there's other areas of domestic law which do enable public participation, which are not directly dependent on those EU directives, which is good, because obviously those EU law can be weakened anyway, given the given Brexit and everything that's going to happen, which I won't go into, obviously. But the one provision I think which has really come to the fore in recent case law is the Local Government Act right to know provisions. So section 100D and B, I think it is. And the right for the public to have access to background papers. I mean, it sounds a really dry area, but in planning decisions, when you have an officer's report recommending quite often recommending approval to a committee to approve a big planning application, quite often behind the scenes, there's internal and external consultations, there's expert reports that have been provided, and they're often relied on in the officer's report and can be relied on quite opaquely. And there's a really good provision in the Local Government Act which enables the right to have those background papers set out and to enable the public access to those background papers before the decision is taken, so that they can properly understand the basis on which the decision is being recommended and actually put in consultation responses to that. And there's been a series of cases from Joycey, I think I particularly remember a few years ago. Then there's a case I did about a waste transfer station called Halebank. And then there's a more recent Kinsey case, I think. And actually the courts have been really strong on that. And whilst it's a bit oblique to some of the more obvious public participation provisions, I think that has really been quite hopeful in how that's enabled the public to have real proper access and understanding to how planning decisions are made. So anyway, those are my just examples of think how it works in practice in my experience. And I'll now hand over to Naomi.
Thanks very much, Jenny. So I will briefly mention the PDR case, Simon, because we were in court yesterday, so it was very present. But I'll just frame that first of all with some reflections from my practical experience of at least 16 years of training communities across England and Wales on how to get involved in the planning system. Because the planning system is obviously where we find our main public participation rights. And it's really important to understand that lots of people don't know that they have these rights to be involved. And it's not a welcoming environment for communities. It's not really encouraged. And for real meaningful public participation to happen, those in positions of power need to cede that power, because otherwise it's not really meaningful as a way to influence outcomes and to actually achieve that substantive outcome that you want on the environment. Because I think it's very much our communities who are our environmental defenders. And the Aarhus Convention encapsulates a set of rights that are basically empowering them to be those defenders. So I think there's an obligation on all of us to share as much as possible the story of the Aarhus Convention and what it means. And I am continually shocked by the fact that I seem to be the only person who mentions the Aarhus Convention in relation to a consultation that the government is putting out, because they haven't even referenced it, even though consultation after consultation, I mean, when you have planning reform, there can be 30 consultations that come out from the government on an annual basis, and every single one of those consultations will suggest changes and will fail to mention the Aarhus Convention when they are talking about changes that have a dramatic impact on either our right to know or our right to participate in decisions. And I think that's one thing that's really clear. Once communities know that devil in the detail of that right to be involved in a decision, they can use that to actually get involved. The real problem is that the devil is in the detail. So we have a lot of statutory instruments that are brought forward, no scrutiny, no consultation, no real parliamentary oversight, no way of actually really refusing them, because you can only really pray against. And, really we should be stress testing every single statutory instrument that comes forward. Does this comply with the Aarhus Convention? Does it comply with Article 6? Are we looking at it in that way? Is that something that, across the sector we're doing? And I would say we're not, because there's so much that's happened during COVID in response to the pandemic, all this emergency legislation, all the Brexit withdrawal legislation everywhere. All these changes are being made. All of these little devils are crawling in through the detail, and we're losing our rights at a rate of knots that I think is just not publicly recognised, because it's very, very hard to communicate. And I'll move on to my permitted development rights case. So here we have a case where these were brought in on the 20th or the 21st of July, literally the last day of the parliamentary session. So you had 6 weeks before they were going to become law. There was no consultation on it beforehand. Well, maybe 2 years before they'd consulted on part of it somewhere else. So in that challenge, we were obviously saying, well, you've made a significant change to the planning framework at the local level. You've basically said there's, roughly 1.5 million buildings that are no longer subject to the local plan. That's a massive change. And it's a really significant change for all of our high streets. But it's a really difficult story to communicate, because of course, on the other hand, you have commissions talking about how, we should take control of our high streets and make these decisions. But if you talk about permitted development rights, people go, what's that? I'm like, well, that's your control of your high street. It's in your permitted development rights and what's been going on there. So I think it's, it's really difficult to communicate that. And yet that is where people have lost a voice over these 1.5 million places or buildings, you know, which could affect them quite seriously. And trying to defend that right to have a say is really hard. It's quite difficult to get that communicated and to get people to understand that that's what you've lost, and you've also lost that democratic oversight. So I think that we're here, you know, if you're looking back at where we are in terms of the Aarhus Convention, if we're looking across, we've still got some substantial rights in our planning legislation. And I think, you know, we see that in section 19, the right to be heard in local plan examinations, you know, although obviously we've only got the committed few who are turning up to those. I would love it if there was more than, you know, a woman and her dog in the next one. But it's, you know, we need many more people to use that. And I think it's really important, Simon, to refer to your thing about virtual or digitization. I think in person is crucial. In person at a local plan examination is very, very powerful. I just, you know, my practical experience would be that is a much more effective way to engage. I think if you can have more engagement, then you can augment that. Because you compare that to the open floor hearing on nationally significant infrastructure projects, which was a really hard-won campaign. I mean, that took a year of my life and Hugh's life to get that one in place, and a lot of horse trading. And it's just a right to speak. It's not really a right to be properly engaged in the decision-making process. And you also have time as a real issue. So time is reducing. The fact that time is just reduced in terms of considering issues, for instance, in the nationally significant infrastructure project regime, the fact that you just don't have the time to look at the issues just means that you can't really participate in those decisions because there's just no time, or you can't get the evidence and time to actually reflect on that in that process, you know, and the process just says, well, that's just how it is. So if you don't get the process right and you don't build in time, you're not going to be making good decisions. So because I think it would be really interesting to answer some questions about this. I'd just make one, I think, plea, and that is whether we should consider a third-party right of appeal. Are we in such a situation now with the planning system in England that actually a third-party right of appeal would be something that would help redress some of the inequality of arms and power imbalance that we experience in public participation in planning? Thank you.
Thank you. That was really thought-provoking, actually, from all three of you. And I think I agree, it would be great if we can just squeeze one or two questions in, which would be really good. I know, again, Ricky, you've got a couple that have been sent to you, and then I'll just draw some threads together just literally for 30 seconds at the end. But if we can get one or two questions in, I think that would be brilliant.
Yeah, I mean, why don't I direct two questions? The first one is a very specific question from Andrew Boswell, who's a transport campaigner, and he says he encounters a lack of transparent information and data about the traffic models on which carbon emissions are based in road schemes, in the environmental statements for road schemes. And that doesn't allow any independent review and scrutiny of the high level and opaque figures published in the environmental statements. This might be a general question for all of you. Can this be challenged as a breach of the convention? But then Andrew also then sends a follow-up question following Jenny's talk, asking if the transparency provisions in the Local Government Act might help in that.
Well, shall I kick off while others more wise are thinking, which is, it's really difficult, isn't it? Because part of the problem with public participation in planning is the vast amount of paper and the way, whether virtually or physically, and the way in which environmental statements have grown like Topsy with massive technical appendices. And perhaps for some people, yes, that information is needed in order to drill down to verify the work that's been done. But I think the challenge is to make sure that the assessment is carried out by people who have the right professional responsibilities and duties, and it is audited by local authorities which are sufficiently resourced with people with the skills to make sure that it's right. And I think we get into an impossible situation if every last model has to be made available for everyone to explore and do their own research on. I mean, maybe others have a different view, but part of the problem of ensuring that there's proper public participation is to make sure that, you know, we aren't just sinking under data and figures, and how to make sure we rationalize what is made available.
Yeah, I mean, I if I could add to that, I think that's right to some degree. I mean, obviously, it's about organising the information. If the information is available and accessible, I mean, the fact that there's a lot of it doesn't necessarily prevent that if it's properly organised. And, you know, doing some planning inquiries over the last year and doing them virtually, and having someone sort out the core documents in a logical way under headings, and so that the documents are properly labelled. You know, there are ways of making that documentation navigable. I mean, the particular issue about models, I think, is difficult because they're quite often proprietorial. They're quite often difficult. I think you have to pay to have various traffic consultants have their subscriptions to the modelling, and I think it's a bit of a black box if you're outside of that, how you get into that. But I think it is really important, actually, and I think this goes back to what Katie was saying. The problem is that quite often, if it gets very technical, it's waved through, or it can be waved through if a local planning authority doesn't have the expertise to properly challenge that. And one of the impetuses behind something like Ahus is to enable others to do that, allow that public participation. And so I think it is, it doesn't happen. I think it would be difficult under the background paper legislation to say that you should have access to every model. I'm not sure the courts would enforce that, but I think it is, the more this is digitalized, the more you can make documents available, the better. And I think otherwise you get to a situation where it's been waved through and not properly scrutinized by the decision-making body. Third parties hone in on it after the decision's been made, but then can't challenge it in the courts because it's too technical and the courts won't get involved on a Wednesbury review. And so you need to have that public participation early on so that you can actually challenge the merits before the decision's made, because once the decision's made, you can't challenge the merits, really. And that's a really difficult conundrum. And I think, actually, interestingly, environmental data on emissions was one case in the High Court where that was actually challenged. And I can't remember the name of the case. Was it Wheeldon or beginning with W? Where actually the court did find an irrational failure in the data relating to road emissions, which affected nature sites nearby. But that was probably one of Katie's examples of where the courts will, or when a particular judge is willing to go into the data and look at it and say it doesn't add up and say it's irrational. But that is by no means a universal, and quite often you'll get judges who won't do that. So I think it is important that people should be enabled that information at an early stage, because I don't think really you can rely on public authorities that are not properly funded to interrogate that sufficiently.
Okay. It's quite a big burden though on people who are participating, because it's quite a lot of information, and you have to have a team and divide and conquer on how much information is available. And the other thing that I think a lot of communities find is that a lot of the data is a PR exercise in some senses, because you're obviously there is something of that going on, and so you need to interrogate that properly.
But I agree, but I think you need the non-technical summary, but you also need the detail, so that if there is someone who is qualified to look into it and is willing to pursue it, they can. I think that you need both, really, ideally.
Right, isn't it? Yeah, I think that case, I think it was Mr. Justice J, wasn't it? I think it was Wheeldon. We're going to have to stop, which is a crying shame, because I can, we could go on for ages, and there's so many things that I would love to talk about. It's been really, really interesting to hear all your views. But I just wanted to say a couple of things before we stop, and then I'll just do a couple of thank yous. As to whether the UK is a rogue state, my own personal view is probably that they're not the worst, but the record, as we've heard from everybody here, on the procedural side is not great. And so what does that mean for Emily's view really about the aspirational living instrument that we want Ahus to be on the substantive side? It doesn't really bode very well. But we have a climate and an ecological emergency. We have to do better, both on the procedural side and on the substantive side, I would say. And I would, suggest that what I think we really need is for these rights, both procedural and substantive, to be in primary legislation. That's something that we're doing quite a lot of thinking about within Wildlife and Countryside Link, the legal strategy group. So we're going to be trying to build some consensus around that. So I'll be coming to all of you and the audience as well for support on that. I'm really pleased that so many of you stayed with us. I know it's a long time and wine is beckoning, but it's really telling that so many of the audience who started are still here with us now. A few thank yous before we close to our wonderful panel. Thank you so much. Really, really interesting. To our marketing team, because they're always brilliant at organising these things seamlessly, Rupi and her amazing team. And then obviously everybody finally for tuning in and listening. Hope you have a wonderful evening, and we can all go off now and get the beer or the wine that we might have been craving. Okay, thank you very much indeed. And hopefully we'll see you at an event again soon.
Thank you very much, Carol.
Thank you, bye-bye.